have a chance to read any of the Supreme Court decisions this morning yet?
Yeah, well, I saw the one from the U.S. Supreme Court.
They've got a couple that came out, but the big one that Gorsuch wrote.
Yeah, about civil rights.
Yeah.
Yeah, it's a great place to start, actually. It's a great place to start, since we're talking about civil rights, the Supreme Court decision. We were glad to join the amicus in that case with other AGs firing someone because of their sexual orientation violates the Civil Rights Act. And that's a great step in the right direction. I don't want to say it's surprising, but as I said to Dan Sutton, who's on our legislative team, when we get good news on this front of the Supreme Court, it's not as often as I'd like, but I'm encouraged by this decision. It's great. So let me start by welcoming everybody here to the office. This was not intended as a formal press conference, so I really don't have sort of prepared remarks. I'm really here to answer your questions if you have them. I mean, the reason for that, frankly, is I really want what we're doing in this office to be about substance and not about statements, candidly. We've spent a lot of time here over the last 3 weeks trying to understand what our role should be. I take the independence of this office and the objectivity of this office as the most critical thing that we need to accomplish. To me, it's not about what you say, it's about what you do. And I think what's been really important for us over the last several weeks is to really think about the things that we can do here to advance the conversation, and beyond the conversation, the results that I think this country needs, has needed for a long time, and we're at a moment in time where hopefully some of these things can be accomplished. And so those things are multiple. Some deal with the inner workings of this office, how we improve as an office, how we train better, how we educate better ourselves internally, how we hire better, how we bring diversity to the office, which is sorely needed and something we've been focused on since I arrived here. Have a long way to go on that front for certain. Some of them are external, things that we need to do with our law enforcement partners around training, around expanded use of body cams, for example, things that I hope to talk more about in the days ahead, not weeks, days ahead, because these things need to happen fast. There are 2 things, though, that are the subject of our press release this morning, which is, I imagine, which is why you're here. One is the civil rights legislation that we announced, and we were fortunate enough to have sponsored in both the House and the Senate last January or February. And that civil rights legislation will be heard by Senate Judiciary tonight. I'm very grateful to the Senate President and his team, and the leadership team, Leader McCaffrey and others in the Senate, for giving that legislation hearing. It's incredibly important, and I know that given COVID-19, the bandwidth for hearing any kind of legislation right now is pretty limited, so I'm incredibly grateful, and I'm hoping that the House will do so as well. I'm really grateful for the conversations we've had with the House as well to try to move the bill there as well. So that's one thing that we're going to hopefully talk about today, and I can answer your questions about today. And the other is the expanded use of force protocol that the office will be issuing within the next day or 2. So if I can, let me just really briefly, again, start with the civil rights legislation. Really, we have a handout that I hope we'll be able to get to you before this is over, but it really accomplishes 2 broad things. One is to expand the scope of the existing civil rights law in Rhode Island in terms of who it covers. So for right now, as of today, it covers race, religion, but doesn't cover things like gender, gender identity or expression, disability, and a few other things. And so for that law to really reach its full scope, to protect everybody who needs protection, it needs to be expanded, as we see from the Supreme Court's decision today. So part of the reason for that legislation was to accomplish just that, both in terms of a private right of action, which exists, but as I said, is not expansive enough, and the right of action that the Attorney General can bring, which is also not expansive enough. And in the case of the Attorney General, it's not expansive enough not only because of the kinds of folks that are not covered by that statute, but also because it does not allow us to take action in instances of threatening or harassing conduct. It only allows us to take action where there has either been property damage, trespassing, or use of force. And yet we know that many instances where civil rights are being violated, or where people are being are being mistreated because of what they look like, or where they come from, or their gender, or how they identify their gender, happens well beyond, outside the realm of physical force, violence, or property damage. And so the statute, as we have proposed revising it, would cover that instance as well. Those things are both critical. What I think is equally critical, and is the major subject of the release we issued this morning, is a provision that would give this office what is called pattern and practice authority. What that is designed to do is to give this office the ability to investigate civilly a law enforcement agency, but not limited to law enforcement agency, but let's talk about it in the context of law enforcement agencies. A law enforcement agency that, because of the way it operates, appears to be violating the civil rights of the people it is intended to serve. Now, that's an authority that has existed in the Department of Justice for decades. It was a tool that the Department of Justice used when I was United States Attorney across the country by many of my colleagues to good effect in Chicago, Cleveland, Seattle, and elsewhere. In the current administration in Washington, my understanding is it's been used only once, and Attorney General Sessions, when he took office, even before he took office, indicated that he did not think that pattern and practice investigations were useful or helpful. I believe that they are. I say that not because I believe that most police officers and most police departments do things the wrong way. I say it because there are instances where some police officers do things the wrong way, and some police departments are not either capable of or are not prepared to do what it takes to fix that conduct. And these investigations can help accomplish that, and have done so across the country. There's a movement afoot in Washington right now to give that authority through the federal legislation to state attorneys general. I think that's great legislation. I don't know what its prospects are. Our legislation, as I said, was something we worked on last year because we thought it was necessary, and it developed into the legislation that we brought before the legislature earlier this year. I think that's a critical tool. I think it's a critical tool because there may be instances where individual acts of misconduct by police don't rise to the level of a crime. Yet there's something about the way that police department trains, supervises, investigates internal acts of misconduct that doesn't lead to either change or remedy. And I think this office can help in that regard. Now, that's not to say that I think that police departments around the state are operating in ways that cause great concern. What I am saying is that, and before I say this, let me say that I think, based on my experience as U.S. Attorney, I'm serving 2 stints on the Attorney General's Advisory Committee for Attorneys General Holder and Attorney General Lynch, where I had a national look in to situations around the country. I think policing in Rhode Island, by and large, is very, very good and very, very strong. We're led by a group of police chiefs that get it. That said, no police department is immune from police officer misconduct. Typically by few, but nobody is immune, and we need to have the tools to make sure we fix problems as they arise. So that is the point of the legislation that was submitted last winter, and I'll be testifying about that tonight. And I'm grateful again to the Senate and Senate Judiciary for allowing me to give testimony. I know, again, given COVID-19, that is not the typical practice. The other item of significance that is mentioned in the press release is the use of force protocol. Let me talk a little bit about that. There has been in existence, I believe, since Senator Whitehouse was Attorney General, a use of force protocol that this office has used when police departments use deadly force, typically officer-involved shootings, or when someone dies in custody. That protocol has worked well. That said, it needs to be updated, and we've updated it. I also think it needs to be greatly expanded, and I'll explain why. There are instances of misconduct by police that don't rise to the level of the use of deadly force or where there's a death in custody. And we've seen some of those cases. This office has charged in the last month to 6 weeks 2 cases, misdemeanor cases involving police officers for allegedly using excessive force, one out of Princeton and one out of Providence. Now, typically those cases would not make it to this office because the alleged conduct there is a misdemeanor. And as I'm sure many of you know, misdemeanor misdemeanor crimes, unless they are investigated by the state police or brought by the state police, don't make it to this office. They are prosecuted by city and town solicitors. Some departments do bring them to us. Cranston did, obviously. Providence has, that has been its practice, and I expect it will continue to be. And there are others that I think would do it. This protocol, however, mandates it. And I think it is really important that we take that next step and expand this office's involvement in its review of allegations of police misconduct. I think it's important for a couple of reasons. I think that there resides in this office a capacity and a capability to make independent judgments about when police misconduct rise to the level of criminal activity. It's what we do all the time. We do it in felonies 6,500 times a year, at least in 2019. I like to think that the expertise and the professionalism resides in this office on a full-time basis to make those kinds of critical judgments as to whether or not a case involving alleged excessive use by police, excessive force by police, in the misdemeanor context ought to be made here and not elsewhere. I think it's also critically important that we see those cases, because while cases involving felonies, cases like the incredibly disturbing and tragic killing of George Floyd in Minnesota, while those cases are obviously critically important and are of the most importance, the fact remains that if we don't catch police misconduct at the assault level, at the misdemeanor level, then it's entirely possible that whether it be in the case of that officer or other officers who see that conduct and that conduct not being held to account, that an assault today may lead to a more serious act of violence later. And so that's the reason for the new protocol. I expect to issue it within the next day or so. Our draft is completed. I've given it to the Police Chiefs Association and other law enforcement leaders, Colonel Manning, for example, to review, but I expect to issue it within the next day or two. And so those are the two things that I'm prepared to talk about in detail today. And there are other things coming from this office, as I said earlier, things that need to be done with our law enforcement partners, revising our use and reviewing and potentially revising our use of force protocols. It's up for annual, or goes every 4 years, it's up for its 4-year review this year, as the case would have it. And so the Interlocal Trust has reached out to us to ask for our assistance in doing that, and we're going to do that. As I said, there are other things this office can do internally and externally, and we're prepared to do that in the very near future. So let me stop there, and I'm happy to take any questions you have.
So this is a protocol, you don't need legislation to change it, it's just something that you can do. What has been the feedback from law enforcement since you sent it to them for their review so far?
Yeah, it's been positive. I've heard from individual chiefs, not the association formally. The association is comprised of 38 chiefs and Colonel Manning. But I've had reach out from individual chiefs. I've had, and not just big departments, small departments. I think the feedback overall will be strong, Tim. Certainly, in the instances of deadly force, we've been using that for a long time, and there has not been any pushback on that at all. And so the way that works, just so you understand it, in those instances, the criminal chief here or his designee goes to the scene when it happens, does a walkthrough with police, from the investigative team, which consists of the state police and the local police department. If it's a state police person involved in the alleged act of deadly force, of the act of deadly force, then it's the state police to this office and the local department where the act took place. So that's done now as a matter of course. As I said, if Providence and Cranston and other departments bring these cases to us already, I would be very surprised if all police departments don't want to do that as well. I think it's good for police departments. They turn to us for guidance all the time. I think this is a place where they should want to turn to us for guidance, and I expect that they will.
So is that the difference with the protocol here? Is normally use of force is, in the world of felonies. In this new protocol, it would be a misdemeanor assault that would normally be handled at the local level and not come to this office.
Correct.
The protocol is now telling police departments, you bring those to me.
Sure. So let me give you an example of a recent case. A recent case, police department has video or access to video about one of their officers. They're concerned about it. The chief of police calls me, we sit around a table, this one, we watch that video, and we make a charging decision, I make a charging decision in the end as to whether or not that is criminal conduct or not. I think that works really well. They didn't have to do that. The Providence, in that instance, Providence, the city solicitor could have made that call. I think it was a good move for Providence to do that. In fact, they've done that in the past. That's not new for Providence. I think every department should approach it that way. For one thing, it'll lead to consistency, and I also think that, as I said, that decision-making ought to reside in this office.
And what if a department doesn't bring a misdemeanor assault to you? Are there any actions you can take? Are there any teeth to the protocol?
Well, look, I mean, the reality is, Tim, is that even though we don't get those cases in the first instance, if a defendant decides to pursue a jury trial in Superior Court, we're going to get it at that point. And so it would be, I would suggest that it would be far wiser for a police department to involve us early than later on. So in other words, let me just make sure I explain this the right way. So let's say a police department in a misdemeanor does not consult us. In the first instance, that would be prosecuted by the city or town solicitor. If the defendant is found guilty, he has an automatic right, or she has an automatic right of appeal to Superior Court. At that point, my office has the case. It would not be wise for a police department to involve my office in a case at that level if I asked for us to be involved at the beginning. So, my sense is this will not be a difficult lift for police departments. The police chiefs that I've spoken to, which are several, have had universal support for it. But I think it's time to institutionalize it, make it formal, and make sure that these cases do come to us.
General, is this something that also applies to other law enforcement agencies, perhaps correctional institutions or private security operations, so on and so forth? I mean, how does this factor in broadly?
Well, certainly if it was a private entity that was using deadly force, we'd be looking at that anyway. So this applies to all law enforcement agencies. It's written, as you'll see when it issues in a couple of days, it's written using the term police departments, but it applies to any state or municipal law enforcement agency. So think state police, DEM, law enforcement, etc.
When we talk about use of force, are we talking about specific actions that may be prohibited, or, I mean, we hear a lot in the media now about chokeholds and stuff like that.
Sure.
And would it apply to any time that an officer draws their weapon? I mean, are there specific guidelines on what force and how it can be applied in situations?
Yeah, so certainly on the deadly force protocol is pretty clear about that, Steve. And you'll see that even if you saw the old one, but I don't know if the old one's ever been released. To me, it's a public record, but I don't know whether anyone in the past has ever put it out. But certainly it walks through that. What we're really talking about here, what I think so critically important about here are circumstances where, typically a person is in police custody and is assaulted by a police officer, or allegedly assaulted by a police officer. He's struck, he's punched, he's kicked, he's smacked, he's slapped. Those are cases that would not ordinarily come here. What comes here are shootings, deaths in custody. The cases that would come here, like the horrible case that happened in Minneapolis. Those cases should come here, of course they should. But I believe that these but obviously not equally, but also concerning acts of alleged misconduct by a police officer need to come here. They need to come here because I think the best decisions will be made here, and also because I believe that if we don't hold officers accountable at that level, we're not going to be able to avoid the more serious acts of misconduct like that which occurred in the Floyd case and in cases around the country. I think it's important to address this kind of conduct early in a police officer's career, not late, and I think this will help in that.
One of the key things you mentioned about the Providence case was video. Providence is one of only, I think, 2 departments in this state that have body cams. I think Newport is the other. I know you briefly touched on it that body cams might be part of your package here. Are you supporting increased use of body cams by all police departments, including the Rhode Island State Police?
I do. Yeah, look, I do. I think, look, I'm a prosecutor. I've been a prosecutor for a long time, state and federal. I can tell you that from where this prosecutor sits, and I'm talking about my experience as a line prosecutor, I'm not interested in what somebody told me about what happened, when I can see what happened. Like, when you're a prosecutor and you're trying a case, you want to know, you want to believe what happened, okay? And the trend lines are pretty clear in this regard. When I was U.S. Attorney, I helped write, along with some of my U.S. Attorney colleagues, the policy which requires all federal agencies to record statements of people in custody. That was a huge lift, particularly with DEA, to get that accomplished. Because federal law enforcement officers just felt like when they testified, we should just take it as gospel. And look, you can do that, whatever, put the percentage on it that you want to pick, okay? But that said, if I want to hear what a defendant said, I want to hear him say it. I'm not interested in hearing it from somebody else telling me what he said. Same thing is true here. If you're a prosecutor, from where I sit, I want to know what happened. And the more we have on video, the better off we are. So look, I know there are challenges with body cams and dash cams. State police, I believe, had dash cams. We've got to come up with ways to fund them, not just the equipment, but how we maintain them. But I'm a big supporter of them, and I hope to do more than just talk about it. I hope that this office will have a role in help obtaining funding for them, and perhaps be able to do some seed money for funding. But more to come on that down the road.
Can we talk about accessing that as media? Like when those body cameras are used, sometimes we put in requests, and I know I've never had one answered. Never had one met.
Yeah, I want to address that, Steve. It's a great point, but Chris, you
Oh, sorry, yeah, Kathy had a question, so I just...
All right, so after I do Steve's, we'll take Kathy's. Okay, great. So yeah, that's one thing that there's a balance between, it's really not a balance in terms of whether it should be released in my judgment, it's a balance in terms of timing, okay? So when I have a case, the last thing I want to do is jeopardize that case, okay? And so when you think about cases around the country, and a prosecutor's obligation to get it right, juxtaposed against the community's desire to know, that's a tough place for a prosecutor to be. My colleague in Minneapolis, Keith Ellison, tough place for him to be. Tough place for the DA in Atlanta. The community wants answers, and understandably so, it wants them now. You got to get it right. You got to figure out what degree of homicide applies. You've got to figure out if I need to turn a police officer, because I need his testimony to get inside the head of the officer who exercised deadly force, and I need to negotiate the terms of that cooperation. Sometimes that takes time. So you want to make sure that your case is right. We've had instances around the country where they haven't gone right. I was talking to a colleague here in the office today about a case in Providence where an independent prosecutor was used many years ago, and that case didn't go right. So making sure we get it right is critically important, because that's justice. On the other hand, the video can provide answers, particularly where the public is concerned to the point of significant unrest. And what we've got to grapple with here in the office and with our law enforcement partners is balancing that interest and, frankly, that need to get ahead of that issue, meaning the public's right eventually, and certainly in near time, to know, against making sure that you don't taint the jury pool. Look, if you're a good defense attorney and you're the prosecutor and you're putting video up and making statements about what this case is in advance of a trial, you're going to see a motion down the road for prosecutorial misconduct, which could lead to dismissal of the case. And so those are the things that prosecutors have to address and have to struggle with. So one of the things, Steve, to your point is, one thing I've asked our policy team to do, and we need to do this in consultation with our law enforcement partners, is to come up with a best practice for releasing video as quickly as possible, but not jeopardizing the ultimate goal, which is to hold anyone who should be held accountable. And that is a very uneasy balance. It's a very uneasy balance. It's easier where it's pretty clear from the beginning, and I can think of a case in Boston involving a case that had links to Rhode Island when I was still U.S. attorney, where Boston police shot an individual who was coming at them with a knife, involved in a national security plot. It was reported on, so you're familiar with it. There the video pretty plainly showed what happened and pretty plainly made clear the circumstances. No problem there in releasing the video. But if you think you actually have a case or may have a case where a police officer or other member of law enforcement, federal, state, municipal, you got to be really careful about that, because it may ultimately impede your ability to bring a successful prosecution. Kathy, did you have a question?
It's a couple. Whoops, can you hear me now?
I can, Kathy. Yes.
Okay, good. First, I have a couple of questions. Number one, about the complaints, misconduct complaints. How many do you have pending now? against police, and I would add to that probably correctional officers. How many do you routinely see now in a year?
Yeah, look, I don't have the actual numbers. I mean, I think one thing we have to do here in the office, we can always pull the data, but we're not tracking it as well as we could be. We're going to start doing that, you know, particularly after the protocol kicks in. I do have a list of what we've seen since 19, and so they really fall into a couple of categories. Some are acts of misconduct or alleged misconduct, if the case isn't resolved, against a police officer or a member of law enforcement while they're on duty, and sometimes when they're not. Sometimes they're acts of alleged misconduct or criminal activity in their personal lives. And so obviously we're dealing with both of those. And so, you know, in 2019, I can think of, you know, based on my memory of that list, I can think of cases involving on-duty misconduct between 4 and 5. Again, though, some of those are misdemeanors that would not come to us unless the department took it upon themselves to bring it to us, or in the alternative, I learned of it and reached out. So that's kind of round numbers. If you include activity by conduct by a police officer or a member of law enforcement in their personal lives, it's probably about the same number. So in my head, Kathy, I have a number of about 10 in 2019. I can't speak for before that because I wasn't here.
Okay. Another question, and this comes from, I don't cover police matters that often, but given what you're talking about right now, police officers' Bill of Rights, I think the general public perception is complaints go there to die, never to be heard from again, and police officers are not disciplined, is a perception. And my question for you is, number one, is that your perception? But also, if you have more tools and more power, is that going to run up, conflict with in any way the police officer's Bill of Rights as it exists now?
Yeah, look, you know, Kathy, I don't have insight into that process in terms of how it works specifically. It's not something that our office intersects with. It just doesn't. It's a function of state law and a function of collective bargaining. Where it does come up, though, is in this, and really comes up in 2 instances, and one of which is addressed by the protocol. The other is a practice of the office that Tim and I have already spoken about. The first place it comes up is in the context of misdemeanor cases where, and look, I'm not thinking of a particular case. It's just come up over the years. It's come up here. It has to have come up while I wasn't here, and it came up when I was U.S. Attorney, although not as directly, because when I was over as U.S. Attorney, we would often be asked about excessive force cases. We brought one felony case when I was U.S. Attorney. Others were misdemeanors that were brought by this office to the extent they were brought at all. Where internal discipline, let's use that phrase, comes up is in this context. So it may be that a department or a police officer may suggest that in exchange for this office not charging a misdemeanor, then the police officer would agree to resign from the force. Because the difficulty, as I understand it, and none of you, although I'm going to say it, I'm going to say, give it this caveat. I'm no expert here. My understanding from talking to chiefs is that if a person or a police officer is charged with a misdemeanor, they cannot be terminated, at least not immediately or without going through the Bill of Rights process. And I understand this point of view. There are departments that say, look, I can get rid of this police officer. I can get rid of this police officer now. I don't have to go through the Bill of Rights process, which takes a long time, can be cumbersome, can be difficult. And whether it's cumbersome or difficult, you know, I don't have personal experience with it, but I have heard that has been stated to me from that perspective. I can get rid of this individual right now, as long as you agree not to charge. And I've reached a conclusion in the last couple of months, as that has sort of reached the forefront of my thinking, that I'm uncomfortable with that agreement. I view my role as this, is to enforce the laws of this state and beyond, but in this context, not laws beyond. I view my mission as greater and broader than that, but in this context, is to enforce the criminal law And what that criminal law is, that if somebody's committed a crime, whether a police officer or not, to bring a charge the same way I would for anybody else. Now, police officers, under the law, have the are able to use force in some instances. It has to be reasonable, but they're entitled to use force. So it's not a direct analogy. But where a police officer uses excessive force and it rises to the level of criminal activity, and I feel the need to bring that case. And so I can see a circumstance, Kathy, where a police department might want me to be willing to do that, but it has been my practice now, and will continue to be my practice, that I'm not willing to do that.
A totally unrelated but very quick question, since I'm the only one not in the room apparently to be able to ask you afterwards. Is anything significant coming from your office at 4 o'clock today?
At 4 o'clock, other than my testimony before the Senate, not that I'm aware of. Of course, in this office, it is a place of 240 people, so occasionally things happen here that I'm not aware of, 3 hours before they happen. But no, I don't anticipate anything on my schedule at 4 o'clock this afternoon other than my Senate testimony.
Let me not make it so specific as 4. Are we expecting any major developments out of your office other than what we're talking about right now?
I'm not expecting to have any other press availability today, if that's your question.
That wasn't my question. It might not be press availability, but are we going to all of a sudden be distracted from you testifying in front of the Senate Judiciary by another significant development out of your office?
Well, I certainly hope not, because I'm looking forward to that testimony very much. So let me leave that there. Are there other questions?
I have one more.
Yes, Steve.
On pattern and practice, I know that we have an issue in Rhode Island from data that of racially police stops, right?
Mm-hmm.
And there's an issue. Would that be something that you could look at?
Yes.
Look at under pattern and practice?
Yes. And I think the best place to look for how this tool can be used is to look at how the Department of Justice has used it in the past, particularly in the Obama administration. Chicago is a great example of that, and we can certainly get you some materials on how it was used in Chicago. The Department of Justice did a report which I refamiliarized myself with over the weekend. And look, these pattern and practice investigations really consist of this. You really do a deep dive into the department. You hear from community voices. You bring in experts. You hear from the police department. And they don't have to be adversarial. Sometimes they can be uncomfortable, but they don't have to be adversarial, and they can lead to some real change. I mean, I want to make it plain that I think, places like Providence, when I was in this office from 1996 to 2002, Providence Police was a very different police department. It was a very different police department. Those of you who've been around long enough to remember those days know that. I mean, when there was a homicide in Providence, the police department didn't call this office. I remember coming into this office, and the criminal chief would say, there was a homicide in Providence last night, and we didn't get a phone call, okay? They didn't community police. They weren't interested in hearing community voices. The police department here in Providence and around the state has really, really changed. That doesn't mean they and we and all of us can't do better. We know there's a tremendous amount of work left to do. Part of it is this. The community has to know who we are. It's why since when I got here, we have really emphasized getting out into the community. It's why we opened our Broad Street office. It's why we did our expungement clinics and met 450 people, mostly of color, who are looking for help in getting their criminal records expunged. We're eligible. More than half were eligible, or nearly half were eligible, and simply didn't know how to do it. Why do you do that work? You do it because it's important and it's helpful, but you also do it because you're trying to link and bond with the community in a way that you won't otherwise as a prosecutor. The community here, regardless of color, sees us most of the time in our criminal division on the other side of counsel table. And we need to see them, and they need to see us in a different context, so we understand them, and hopefully they see something about us. And here's something else that's really important about those expungement clinics. The prosecutors from this office who participated, and we typically had a team there of 18 people, all right, saw the impact of their sentences on people. Every prosecutor should think about the impact of their sentence before they recommend it. I remember one man there who wants to be a correctional officer in the worst way. His brother's a correctional officer, his uncle's a correctional officer. He had a criminal charge when he was 18 for which he received a 10-year suspended sentence, okay? He's got to wait 20 years until he's 38 to get that record expunged so he can then pursue his dream of being a correctional officer. He's 2 years out. He's never committed another offense since his 18th birthday. He's been a good citizen since then. And yet he can't pursue the job of his dreams, okay? And so when my prosecutors hear that, and I hear that, we should think about, when you're recommending a 10-year sentence, make sure you really need a 10-year sentence. Because if you don't, it's not just another file that goes back to file control. It's that 38-year-old man, that black man, who can't get the job of his dreams, who never commits another crime for 20 years. But why do you do that work? You do that work because you hear stories like that, and it makes you think about what you're doing. And hopefully, it begins to build some trust between some segments of the community in this office. We've got a tremendous way to go there. A tremendous way to go there. But that's why we do that work. And one of the things about COVID-19, beyond the obvious tragedy that is COVID-19, that has most disappointed me, is to ground that work to a halt. We had 3 other clinics planned through May, and we couldn't do them. Now we're working on ways to make that happen remotely. But even when you do that expungement remotely, we're not having the in-person connection with the community that I think is so critically important. So look, this office has a long way to go ourselves in terms of our own hiring, in terms of diversity in this office. But I'm committed to doing it and moving the ball forward. And I want to do it through things that matter and things that actually comprise action. And that's why this legislation tonight is one piece of that. I honestly cannot think of one reason to oppose this legislation, right? If it's about getting it right, if it's about holding those officers, that minority of officers that don't act the right way, if it's about getting it right, if it's about making our police departments as good as they can be, there's no reason to oppose this legislation. None. If it's about making sure that the decisions are done independently in the right way, there's no reason not to be a fan of the protocol that we're going to push out in a couple of days. So, look, this is a moment in time for this country where we can drive real change through real things, and we should take advantage of it. We shouldn't lose that momentum. And I'm committed to trying to help as much as I can. Go ahead, Bill.
General, that would actually be my next question, is how much is the moment in time that we're in right now factoring into your decision to, first of all, for us to be here right now, and how much in your conversations with Judiciary Committee members, are they on board with the notion that we're in this moment in time? I know it's a bit esoteric, but
Sure.
Are we,
Well, look,
are you there?
Well, look, I will say this. This legislation was something. When we ended the legislative session last year, we went back, as we do now in this administration, it was our first year. We go back, what are our priorities going to be for next year? What do we want to accomplish in the next legislative session? This legislation grew out of that. So this is not a new notion for this office. We thought it's been important for a long time. But there's no question that at this moment in time in our nation, that this pattern and practice authority is more critical than ever. I find it incredibly interesting that at the same time that we are now bringing this up before the Senate Judiciary today, the Congress is thinking about giving the same authority to attorneys general across the country. It's critically important, and it's critically important to use this moment in time to bring attention to these issues and make sure that they go forward. So yeah, Bill, look, I think they've always been important to me. This protocol is something that we have been looking to update for a long time. I will say that in the wake of the cases that came in here before Mr. Floyd's death, the misdemeanor cases out of Cranston in Providence, I thought to myself, this is the way this should work in all cases. Why aren't we doing this across the board? And why shouldn't this be part of the protocol? The other thing, Kathy, to your question, you asked about the Bill of Rights and how it intersects with the office. The other place it intersects, and the protocol will address this, is that a police officer under a Supreme Court case from 1967 called Garrity does not have to give a statement when we are investigating a police use of force incident. And the reason for that is they have the same Fifth Amendment privilege that all of us in this room do. Now, the difference with a police officer is they can be ordered by a supervisor to give a statement. When they do that, that statement cannot be used against them. And that we work around that. It comes up, frankly, fairly routinely. What that does is we then put together 2 teams. One team that, or the investigative agency, sets up one team that takes that statement and may use that for internal discipline. We then, on the criminal side, don't have access to this statement, and we have to make sure that we put up a wall between those 2 investigative units. So it comes up, Kathy, in that context as well. I neglected to mention that earlier.
I have a technical question about the civil rights bill you'll be testifying to tonight. And you mentioned you can't see any reason why anybody would be opposed to it, but sometimes lawmakers and courts are uneasy with a law that's worded too broadly. And you have the language in here, whenever it appears to the Attorney General that a person has engaged in so on and so forth. Appears is a pretty broad word that would give your office all these powers to do these investigations. What's the threshold for appears?
Yeah, look, I think it's something, I think that exercise of discretion is something that prosecutors across this country exercise every single day. Every single day. What prompts a grand jury investigation in anything? It's when I have evidence which makes me concerned about what's going on and I feel the need to do something about it. That's the job that I'm entrusted with. If people don't like the job that I'm doing, well, that's why we go to the polls every 4 years. I mean, I think that exercise of discretion is critically important. You know, criminal investigations, for example, all kinds, don't start with probable cause. They start with reasonable suspicion. This is a civil action we're talking about, so the standard is less. So we hear that a lot. Well, there's no probable cause. Well, probable cause is not the basis for initiating a criminal investigation. Really, it's whether or not there is sufficient evidence for a prosecutor to believe that additional inquiry is necessary. So look, I take the responsibilities of this office very seriously, like I did my last one. I think how I exercise my discretion and judgment is critically important. It's not my goal to waste people's time or to conduct kangaroo courts in any fashion. But where there's conduct which is concerning, and you get to a point in your career when you know where that is, then this gives us a tool to address it. And look, you look at, I'd ask you to go back and look at the federal statute, which is drafted differently. It focuses only in on, I think it's I'm not sure which section of the U.S. Code is, but it's 1441.1, I think. But in any event, it really focuses in on police departments. I think there may be instances where an entity other than a police department could engage in a pattern and practice of civil rights violations. A bank, for example, could decide not to lend in particular neighborhoods. So I think this authority ought to be more expansive than just to police departments. But in terms of what triggers it, what triggers this is a sense on this office's part that there has been a wrong, and someone ought to do a look in to see whether that wrong is in fact happening, and if so, what steps ought to be taken to remedy it.
Have you talked to House leadership or anyone from your office?
We have, yeah, we've reached out to House leadership and the Senate leadership, and well,
What did they say?
I make my pitch, Tim, and they say that they will consider it, for which I'm grateful. That's all I can ask.
General, you said, Rhode Island policing is strong to begin with, but I believe you said no department is immune to misconduct, right? So having this pattern or practice investigations, we've seen a lot of criticism at the federal level. How do you think people will see immediate change from that? We're seeing calls to defund police locally, regardless of how strong Rhode Island policing is. What do you hope the community sees from these changes that you hope to make?
Look, I hope what the community will see is that, look, there is a tool in the toolbox. It exists federally. It's not being used, okay? Even if it were being used nationally, it's not going to be used in a small state with a small department. Even Providence, by federal standards, is a small department. I was a federal prosecutor for 15 years. We only did big cases. We did 100 cases a year, and they all had to be huge, okay? That's just the way it was. So, and I think that may be driving some of the federal legislation. So I think there are two takeaways. One, it's a really useful tool and has been used to good effect to drive change in departments that need it, number one. Number two, if it's a tool that the federal government will never use at all, let alone in a smaller state or a smaller department, then perhaps an attorney general, as we do for most of the felony cases that exist in this state, can fill that role. Again, like many things, I think it is a tool that we need to have. I'm not asking for it for any particular reason, because I have any particular department that I'm concerned about. I want the tool to be there when I need it, and since we don't have it now, I think we ought to get it there. I think it's sort of like my grand jury bill. We put that bill in not because I had any particular thing in mind, but it's another example of why tools that will allow for transparency can be really helpful. Imagine a grand jury bill that will allow a grand jury report to issue when no criminal charge is brought, but can talk about what happened, why it happened, and how we can fix it. How useful would that be? How useful would that be? That's why we proposed it. I don't have high hopes for that one, but we're going to keep pushing it year after year after year, because I think that's important. I think it's important that people understand the decisions that we're making and why. They may not always agree with them. I've been around long enough to know that. But I think it's a tool worth having. Other questions?
Well, all right, I'll ask it. To fund the police, she brought it up that
Yeah.
the spectrum is shut down police departments to.
Yeah.
I'm assuming you're not on that end of the
Sure.
spectrum. But what about the question of moving funding that goes towards police departments to other social service programs? What do you think about that?
Yeah, look, my first reaction is, why does it have to be a zero-sum game? Why does it have to be a zero-sum game? I thought, those of you who've heard me talk for a long time about probation and parole, we don't do as well as we could in this country, in the state, and in the country, but in the state, with respect to how prisoners, inmates, releasees, returning citizens do when they come out, because we don't invest in probation and parole. We don't do it. We talk about criminal justice reform, but we don't invest. Right? If you're a probation or parole officer and you're carrying hundreds of people on your caseload, how can you possibly effectively, and some do it anyway, but how can you possibly effectively help that person get back to where they need to be for society's benefit and their own? You can't do it. We're not investing there. So I don't know that it has to be a zero-sum game. Why can't we fund police and fund these other things? I think that we can if we're committed to it. You take Providence's police, Commissioner Parry and Colonel Clements are much better authorities on this than I am. But I've sat in that command staff room, as some of you probably have, and I've looked up on that board as to what their authorized strength is, who's actively on duty. And I saw a former colonel just the other day in Providence, and we were talking about community policing. There was a time when Providence policed like a 600-person agency because they had the overtime. Now, to me, that's not policing in militaristic fashion. That means you can have 9 or 7 community policing stations instead of 5, because you can staff all 9 of them the way we once have. Okay? That means you can get officers out of cruisers and on bikes or on their feet because you have enough of them. But if we're not investing in police and these other things, I don't know how we get to where we ought to be. And so I don't view it as a zero-sum game, Tim. I view it as an investment that we ought to be doing across the criminal justice system. Take the legislature, great example. They invested in a diversion court. What a great thing that was by the House and Senate to do that, and for the governor to sign that bill that went into effect in January. We're diverting tons of nonviolent offenders out of the criminal justice system for their benefit and the system's. That's an investment. It's an investment to do that, but it's going to reap long-term reward. So I understand the sentiment, but I don't think it's a zero-sum game. I think it's a priority analysis. What do we prioritize? We ought to be prioritizing making sure that policing is done the right way, keeps people safe, and also we have the tools to address those instances where police are called, but it's not a police matter.